Good afternoon. I'm Caroline Fredrickson, Executive Director of the American Constitution Society for Law and Policy. Welcome to this afternoon's panel, The State Secrets Privilege, Case for Reform. This panel was designed to address some of the challenging issues surrounding the state secrets privilege, a privilege that allows the government to prevent the disclosure of certain information in legal proceedings, even if no federal agency or employee is a party to the proceeding. Over the past 8 years, there has been much discussion about reforming the state secrets privilege. While the privilege's rationale has been to avoid disclosures damaging to national security, invocations of the state secrets privilege in court by both the Bush and Obama administrations have left some observers to claim that the doctrine is being abused by the executive branch. With the stalling of bipartisan legislation such as the State Secrets Protection Act in 2008 and the announcement by the Department of Justice of a new state secrets policy just a few weeks ago, many legal and policy questions remain. Is the state secrets privilege being invoked too frequently or too broadly? How can national security concerns be balanced with the need to preserve meaningful access to justice in our nation's courts? Is a legislative solution still in order? These are challenging questions, but happily we have a panel of experts who are more than up to the task of answering them. Our moderator will introduce the panelists, but I have the honor of introducing our moderator for this afternoon's panel, Professor David Cole. I will touch on only a few of David's many accomplishments, since you have a fuller biographical description in the handout. David serves as a professor at the Georgetown University Law Center, where he has taught and published in a variety of different areas, including civil rights, criminal justice, national security, and constitutional law. After clerking for Judge Arlen Adams of the United States Court of Appeals for the Third Circuit, he became a staff attorney at the Center for Constitutional Rights, where he litigated a string of high-profile First Amendment cases. David is the legal affairs correspondent for The Nation and the author of numerous award-winning books. His latest book, The Torture Memos, Rationalizing the Unthinkable, was released just a few months ago. It is a pleasure to have him here. David?
Thank you, Caroline, and thank you to ACS for organizing this day and this panel. The state secrets privilege really comes at the intersection of the balance between, on the one hand, transparency and accountability, and on the other hand, the government's legitimate interests in keeping information secret whose disclosure would undermine the national security. The rule of law, of course, requires transparency and accountability, but national security sometimes requires secrecy. Secrecy, of course, can be invoked for legitimate national security concerns or for illegitimate concerns about avoiding embarrassment and, in fact, frustrating transparency and accountability. And the state secrets privilege really sort of presents that conflict in a very, very specific context, and one that has been the focus of a great deal of litigation in the post-9/11 era. The privilege dates back to the Supreme Court's recognition of it in a case called United States versus Reynolds, a case which, ironically enough, turned out to be an instance in which the government invoked the privilege for illegitimate reasons to avoid embarrassment, but that was not disclosed until many, many years later. And it is invoked in really two kinds of situations. One, the sort of traditional privilege where the government says information is a secret and therefore we shouldn't be required to disclose it, just as attorney-client privilege or spousal privilege or priest-penitent privilege protects confidential information from disclosure. And that is not a particularly controversial application of it, although the scope of it can be debated. But the second way in which it is invoked is as a kind of affirmative defense. I've often called it the nuclear option for the government in litigation, in which the government says, not only do we not want to disclose this secret information, but because we don't want to disclose this secret information, you, the plaintiff, can't proceed with your lawsuit challenging us. And in this context, the government has invoked it both to defeat accountability for its rendition and torture programs. In the case of Mr. Maher Arar, who I represent with the Center for Constitutional Rights, Khalid al-Masri, who the ACLU represents, and they're attempting to do so in the Jefferson Data case out in the Ninth Circuit. They've also done this with respect to the NSA wiretapping program. So in both of these instances, the claim was the government has acted unconstitutionally, criminally, and in the context of torture, in violation of one of the most fundamental human rights recognized by humankind. And in response to that, the government says, well, maybe we did, but if we did, it's a secret, and therefore you can't litigate it. That's the more troubling way in which it is presented. And we're going to discuss on this panel the whole panoply of issues raised by the state secrets privilege. They are currently a matter of public debate, both because the Obama administration has introduced some internal reforms to try to respond to some of the criticisms made of the Bush administration's invocation of the privilege, and because there are two bills pending in Congress that would impose some more important, in my view, external constraints on the invocation of the privilege. To discuss the issue, we have a panel of truly highly qualified experts. Their full biographies are with you, so I will only say briefly that Vince Warren is the executive director of the Center for Constitutional Rights, which has been at the heart of many of these disputes. Ben Weisner is a staff attorney at the ACLU, also at the heart of these disputes. Amanda Frost is a professor at Washington College of Law and teaches on these issues. And David Rivkin has the good grace to come into the lion's den and defend the other side, a position I sometimes find myself with him at Federalist Society events. So it's always nice to see David, and he's always willing to stand up for what he believes in, and we have to give him credit for that, even if we disagree with it.
Do you want us to stand? Do you want us to stand?
I think whatever if you prefer to speak from the mic, that's fine.
I'll speak from the mic. Can everybody hear me? It's wonderful to be here. I want to thank ACS and Caroline Fredrickson for asking me to appear before you. David had asked me to talk very generally about the state secrets privilege and how we got here. So I'm going to lay that out briefly, and I want us to focus and think about the concepts of transparency and the concepts of separation of powers. And I think both of those issues are at the very heart of what is troubling for many of us around the issue of the invocation of the state secrets privilege. In its most basic form, the privilege involves the government submitting an affidavit, and the affidavit will come from a department head, and it will say that any court proceedings at issue in this case would risk disclosure of secrets that would threaten and cause grave damage to national security. So we're going to ask the court to dismiss the lawsuit based solely on those grounds. Previously, invocations of the privilege had been in a slightly different forms. Government had asked the court to deny litigants access to documents in the discovery stage of the case. But more recently, and certainly under the Bush administration and moving into the Obama administration, the government has moved to dismiss a range of cases, as David noted, among them Maher Arar's case that the Center for Constitutional Rights works on with David, and the Khalid al-Masri case that Ben Weisner and the ACLU are working on, that they've sought to dismiss these cases at the pleading stage. The government has essentially argued that even to answer the complaint, even to join the issue with the court would cause such grave damage to national security that the cases must be dismissed. I think it's fairly obvious that an assertion that is that broad and that is that deep has severe ramifications for the concepts of transparency and for the form of government that we have and the separation of powers which we hold so dear in this country. What's interesting about the government's assertion is that the courts have a range of options that they employ routinely and all the time, and even in the context of sensitive national security cases, that the courts can use in order to protect the information that the government is so concerned about. Typically, the court will close a courtroom. They will place briefs under seal. They'll make the other attorneys promise on a stack of Bibles that they won't divulge the information. Or as in the context of what the Center for Constitutional Rights and other organizations are seeing in the context of representing Guantanamo detainees, they will require lawyers to seek high-level security clearance and have protective orders involved in the cases so the information can come out. But essentially what the government is saying with the state secrets privilege is that there are some secrets that are so secret that we don't even trust the judges to look at this information. And that's where we get into the question of separation of powers. One of the issues that I thought was interesting with respect to the last speaker when David Criss was talking, I think he floated a number of concepts about what's different about how this administration is moving forward with respect to national security. But one of the concepts that I was most interested in was what's the answer to the question of who polices the administration in terms of doing these things. What I heard largely was we're doing it differently, we're doing it better, we're different guys and women, and that should be good enough. But I think it doesn't necessarily satisfy some of the concerns that certainly that we have at the Center for Constitutional Rights with respect to government activity, whether it is legal, illegal, or simply troubling. So if it seems to you that the idea of the privilege contradicts the separation of powers and the power of judicial review, it certainly does. The Cold War era case that David has referred to is United States versus Reynolds. In the United States versus Reynolds, the Supreme Court noted that the cases that were discussing the broad privilege, it had been limited in the United States up to the 1950s, but it had had a deeper application in England. And what's interesting about importing this doctrine essentially from England is that they have a very different relationship with the separation of powers than we do in the United States, namely that it doesn't exist in England, that they believe essentially in parliamentary supremacy, that even the high courts at some level are connected to the parliamentary process. The prime minister is connected to the parliamentary process, and that the parliament gets the last word on these things. In the United States, of course, we've typically allowed the courts to have the last word with respect to some of these legal issues. And so importing the privilege from England, I think, was a fairly was a misapplication and I think a miscalculation, really, of how well that privilege would fit. And I think that, at some level, foreshadowed some of the tension that we're seeing today. Specifically with respect to Reynolds, it was about a case involving a lawsuit with a B-29 bomber that had a lot of intelligence equipment inside of it, and it crashed, and it killed several civilians that were on board. The widows sued. The government withheld the official accident report. It wasn't released until the year 2000, 52 years after the case, after the crash. And when the report was declassified, it didn't have any national security secrets. It didn't have mission plans. It didn't have special documents or technology. Essentially, what the crash report showed, that the crash was a result of pure negligence. The civilians were not trained to bail out of the plane when the plane was going to crash. And so what we see as a result of that case is not just that the government was invoking the privilege where there was no national security secret. But we also see that in addition to that, as if that weren't bad enough, that the government was invoking the privilege essentially to avoid embarrassment. And those are some of the issues as Ben and Amanda and David conduct their discussions today that we need to keep in mind. That the premise for us really is that if we don't have judicial review of executive department assertions, there really doesn't seem to be a way for us, meaning us, the fourth branch of government, the people, to be assured that the government is not doing things that we don't want it to do. Congress can pass various laws, but the question for us really is how do we begin to assure transparency so we know what's happening, and we can all agree and to disagree or agree to agree on where that line is drawn. But the bottom line is this: is that simply saying in a new administration that trust us, we're the government because we're different guys, is the exact same logic that got us into the point that we're at right now. And in fact, the very invocations by the Bush administration, they were saying, trust us, we're the government. And the Obama administration is asserting the state secrets privilege in the same manner, saying, trust us, we're the government. But the bottom line is people like Khalil el-Masri and the other plaintiffs in these cases are not able to move their cases forward and to get judicial determinations. Thank you.
Thank you, Vince. One of the key prerogative of a moderator is to keep people within their time, and Vince did a tremendous job. It's always good if the first speaker stays within his time to set a precedent, because otherwise everybody feels that the rules are gone. So, Ben,
gun on there, so that's what actually comes.
Ben, it's your turn.
It's the clearest precedent I've ever had to follow, I think. But thanks, David. Thanks to ACS. It's nice to be here with these fellow panelists who are people who I've either worked with or, in one case, been attacked by in the nation's leading newspapers. In 2004, when I first became an involuntary expert in the state secrets privilege, had we had an event like this, it might have been difficult to fill this table, not this room. Of course, today, not only is this the topic for a symposium, but we have two bills in Congress that would reform the state secrets privilege. We had the President of the United States asked about the state secrets privilege in a primetime televised news conference. And so what's happened between 2004 and now? Well, unfortunately, we're all familiar with this. In those years, a relatively obscure common law evidentiary privilege has been employed to permit the executive branch to violate international treaty obligations, constitutional guarantees of access to court, core principles of separation of powers, and the duty of the courts to say what the law is. We've seen the executive branch engage in kidnapping and torture, declare those activities a state secret, and by virtue of those declarations alone, avoid any judicial examination of conduct that the entire world agrees is illegal in all circumstances. What's more, that's occurred when the perpetrators themselves have submitted affidavits to courts demanding that cases have been dismissed. We've seen the President of the United States decide that the Constitution permitted him to disregard a statute enacted by Congress governing electronic surveillance. And when challenged, to argue that only those who could demonstrate conclusively that they had been surveilled could bring a case, but that no one could do that because the identities of those victims were state secrets. In both cases, the executive branch used the state secrets privilege before any evidence had been requested by any plaintiff, before any evidentiary dispute had arisen. It was used instead to terminate entire lawsuits before they even began. And in that way, I think the two most controversial policies of the Bush administration, and that is the torture of prisoners in secret detention and the warrantless surveillance of U.S. citizens, have entirely escaped judicial review. No court has yet adjudicated the legal or factual allegations at the heart of the many torture lawsuits that have been filed. No court has said these facts that you're alleging are valid or invalid. No court has said that the conduct that you're describing is legal or illegal because of the state secrets privilege. And no court has definitively resolved one of the core separation of powers issues of our day, which is whether the president had the constitutional authority to disregard a statute that was enacted precisely to govern the executive branch's use of electronic surveillance. I think this is important because so much of the discussion in state secrets cases involves the sincere regret of courts that, unfortunately, in some cases, the interests of plaintiffs in having their rights vindicated must be subordinated to the greater good. This was the term that the Fourth Circuit used in the El-Masri case, subordinated to the greater good in the public interest. But I don't think that the greater good is served by undermining constitutional checks and balances. I certainly don't think that the greater good is served by removing critical constitutional disputes from the purview of the courts. I certainly don't think that there is any public interest in preventing victims of grave human rights violations from having a forum. And on the contrary, there is a strong public interest in preserving that kind of forum. Vince just talked about the Reynolds case, which is, certainly makes the case that the whole doctrine is fruit of this poisonous tree. But keep in mind that Reynolds was a tort case. El-Masri was a torture case. There was no allegation in the Reynolds case that the government had acted illegally, certainly no allegation that it had violated the Constitution or human rights obligations. And I think that a strong case can be made that a set of rules that was created for one circumstance really has not served the test of time, given the kinds of cases that are being used right now to which the state secrets privilege is being applied. I want to make another point. I'm going to try to stay within my 5 to 7 minutes and save time for your questions. In my view, it's more useful to think about these cases as not being about secrecy, but about immunity. And I think the Ninth Circuit Court of Appeals, in one of my cases, the case brought by 5 rendition victims against a Boeing subsidiary, understood that. The Ninth Circuit said there's no limiting principle here. You are essentially asking the judiciary to cordon off entire categories of executive misconduct from any judicial review. And listen to the government's arguments in these cases. The government's arguments are not about release of information. They really are much more categorical than that. The government says we may never confirm or deny allegations involving clandestine intelligence opportunities. We can't tell you what contractors or companies we work with in any instance, not just this instance. They say it's irrelevant that we have eyewitness testimony from former employees of these companies telling us exactly what went on there. That it's irrelevant that we have, for example, flight records, invoices, government investigations from other countries that really lay out a case without any need for discovery. All of that stuff doesn't defeat the government's categorical right to say that you can't bring a lawsuit against a CIA contractor. Why else do I think that this is about immunity? Because the government isn't only saying that you can't get any documents or information from us. The government is saying you cannot even prove your case or attempt to prove your case with the evidence that you already have in your possession. And if this were really fundamentally about secrecy and not immunity, why not find a way to compensate an unquestionably innocent victim like Khalid al-Masri? There would be no need for any information to be revealed in court in order for the government to make Khalid al-Masri whole. And the fact that there is no attempt to do that suggests that there's something else at stake. For many years, the Bush administration and its defenders claimed that the activities that I've been describing here were perfectly legal, that they did not constitute illegal torture, that they did not constitute illegal surveillance. They drafted legal memos to support those positions. I, in fact, even see some of those people on my TV today still saying that this activity was all perfectly legal. But at the same time, they've been working diligently, desperately, and successfully to prevent any court from ever resolving that question. And so we're in a place almost 1 year into the new administration where we still have not had the branch of government that is charged with saying what the law is, determining whether this conduct is legal, to have an opportunity to do that. We have to find a way for courts to be able to resolve these critical legal questions without divulging legitimate secrets. We have to find a way for victims of grave human rights abuses to obtain justice and compensation without divulging legitimate state secrets. And I would argue that in the cases that I've been involved in, the government is not attempting to keep secrets within the temple. It is attempting to keep criminals outside of prison cells.
Okay, 2 for 2. Thank you, Ben. And we're next going to hear from Amanda Frost, who's going to talk about what the Obama administration has done to try to respond to some of the concerns that Vince and Ben have raised, and what Congress is considering doing.
ACS timed this panel well because it comes just a few weeks after the Department of Justice issued a memo on September 23, 2009, in which it described new policies and procedures for invoking the state secrets privilege. And this memo was inspired, at least in part, by the public outcry that followed from the Obama administration's decision to support and continue to defend broad claims of the privilege in ongoing litigation. In particular, in Ben's case in the Ninth Circuit, where just a few months into the new administration, the government showed up at oral argument and reaffirmed the claim that the privilege required immediate dismissal of the lawsuit even before any discovery or an answer to the complaint claiming that Ben's clients had been the victims of extraordinary rendition to countries that tortured them. So after the public reaction to that, at least in part, the Department of Justice agreed to re-examine the ways in which the privilege is invoked and defended. So I'm going to briefly outline the policies in the memo, and then I'm going to describe why I think those new policies, while helpful and not unimportant, nonetheless should not take the place of legislation that would involve the courts and maybe even Congress in overseeing the privilege. So the first thing the memo does is give a standard for when the privilege should be asserted. And it said the privilege should only be asserted when necessary to protect information which, if disclosed, could reasonably be expected to cause significant harm to national security. And in addition, the memo suggests that the privilege, that the Department of Justice will make an attempt not to use the privilege as grounds for immediate dismissal of cases, as the Bush administration and the Obama administration have done, but to use it more as an evidentiary privilege, a limited privilege applying just to specific information. And I think the most important new set of policies in the memo involves 5 levels of review within the Department of Justice, of internal review. So if the department or agency involved in litigation wants to assert a privilege, the memo explains the head of that department or agency must first provide a detailed declaration justifying the privilege. That declaration then goes to the Assistant Attorney General, responsible for the division of the Department of Justice that would defend the privilege. That Assistant Attorney General, after reviewing the declaration, issues a formal written recommendation, and that recommendation gets sent to a State Secrets Review Committee. That's a committee of high-level Department of Justice officials that will be appointed by the Attorney General. It's created, as I said, by this new policy in this memo. That committee will consult with the agency head, with the Director of National Intelligence. Itself will reach a recommendation about the use of the privilege. That recommendation goes to the Deputy Attorney General. And finally, the Attorney General, him or herself, is responsible for making the ultimate decision about whether the privilege will be defended in litigation. Finally, the memo describes procedures for referring matters to the Inspector General. If, for example, the Attorney General thinks the privilege is necessary and needs to be invoked and defended in litigation, but nonetheless the case itself raises credible allegations of government wrongdoing, then the Attorney General will refer the matter to the Inspector General, and there's some provisions for reporting to Congress. So the question is this change in policy important? Is it something that we could rely on to curb or rein in what a lot of people, including some in the Obama administration, see as overuse of the privilege? And I think the cynical reaction to this memo is that the concern that it will take the wind out of the sails of the pending legislation in Congress, and that perhaps that was even part of its purpose. In Congress right now, there is pending legislation seeking to restrain, limit, structure the way in which the state secrets privilege is asserted in court. And in particular, the State Secrets Protection Act, this pending legislation, would seek to involve the courts much more actively than they have been in limiting or reining in the use of the privilege. So, for example, the courts would review the evidence that is claimed to be privileged in camera. They could arrange for a guardian ad litem with security clearance to review that information and engage in an adversarial exchange about whether the information is privileged along with the government. There would be a possibility for counsel opposing the government to get security clearance and engage in that adversarial exchange. Summaries of the information could be used in litigation to allow for lawsuits to go forward that up till now have been dismissed on state secrets grounds. So the legislation involves the courts much more actively than they have been. It also seeks to involve Congress by requiring mandatory reporting to Congress about use of the privilege. And so I think I'm just echoing what some of the panelists have already said. When I compare the Holder memo and the new policies and procedures, internal procedures for checking the assertion of the privilege in the Department of Justice with the potential for this legislation, I think the Holder memo is lacking, because for all the benefits of internal review and checks, at the end of the day, it's still the executive that would be deciding when the privilege could be asserted. And as we've already discussed, the executive has a lot of strong incentives to over-assert the privilege. For the most pernicious reason would be because they are embarrassed by the legal claims against them. There's a valid constitutional claim against the executive, and the executive wants to duck the bad publicity and the results of litigation on that matter. That would be the most pernicious use of the privilege, and obviously one that we would all seek to avoid by getting courts more involved. But I'll just add, there's there's a more benign reason why we might think the executive isn't a great policeman of the privilege. And that is that, and understandably I have some sympathy for this, it's always in the interest of the executive to overclassify information, because the harm that they see coming from overclassification is very little, right? They hope they'll do the right thing, they'll police themselves, and they'll protect information that might possibly harm national security. Whereas they think, well, if we make a mistake in the other direction, we could put the country at risk. So even if they have those benign motives, the executive is always going to think better to overclassify. And we see that again and again in other contexts, like the Freedom of Information Act. So that is partly why I think it's extremely important to get another branch of government involved in oversight and the use of the privilege.
Thank you, Amanda. Our final speaker is David Rivkin, who gets a little additional time if he wants it.
I will surprise you. First of all, pleasure to be here, and thank you to ACS. And I let the record show I enjoy coming to your gatherings as much as I enjoy coming to fellow society gatherings. But also thank you to David. I enjoy our debates, and I hope to surprise you with a modesty and reasonableness of my position today.
You always do.
Let me just quickly, and there's some benefit in going last, let me quickly run through things that at least interest me and hopefully you would share that interest. We can have a nice esoteric debate about what is the proper way of thinking about state secrets privilege. Is it really a common law privilege? If I wanted to be frisky, I will tell you there is not much federal common law left these days, and in any case, it's not inherently robust. And much as I like foreign and international law, the exact parameters of the British use of a state secrets privilege, precisely given the fundamentally different constitutional architecture, are not particularly compelling from my perspective. But I agree with Ben and Vince as well, but I agree with Ben who articulated it well. It's really a question of dueling narratives. These are narratives. So to me, the interesting debate is not the legalistic debate. Also, the parsing of Reynolds, in what way was it used there? They teach you in first year in law school that you look to the broader underlying holding of a cases, or the fundamental proposition as the case law develops. And, if a case dealt with a Blackacre, it doesn't mean that the next case has to deal with a Blackacre. To me, it's not particularly interesting. But I also think it is about both immunity and secrecy narratives. And let me hopefully march through and try to give you a different take on some of the points being made today. Well, first of all, we've heard that the privilege has been abused, both because it's been invoked much more often, ladies and gentlemen, and also in a sort of abusive manner. But let me save the second point for a second. Well, there are perfectly benign reasons why the privilege has been invoked much more. We're in a post 9/11 world. There's a great deal more of imperative and vital secrets to protect. And quite frankly, I don't begrudge it to my colleagues and friends, but there's a lot more litigation being brought to bear in an effort to, let's be frank, not just to help the victims of some wrongdoing, but fundamentally change the government policies. The litigation is pursued in effect as a tool of changing governmental policies. Nothing wrong with that, but we need to understand what it is. So the fact that the privilege has been invoked many more times is both, in my view, derived from the fact that their compelling need to keep secrets is here, and there's a lot more litigation about it. Now, what about the argument we've heard that you have, privilege being invoked in cases involving contractors, particularly most famously in the NSA cases? Well, we live in a world, ladies and gentlemen, that government contractors perform vital governmental functions, both in the context of warfare and theater of operations. We have private contractors who serve meals and provide security and fly planes. It's apparently the case with Jepsen. And I think I wouldn't be disclosing any secrets, not that I have a clearance these days, that the NSA could not have engaged in most of the functions in the new world of fiber optics without not just some cooperation of the private sector players, their service providers, but they needed a fulsome cooperation where the service providers actually had the best idea of how to ferret out data there. So, I mean, it's supposed to be progressive and not to be formalistic. So why are we hanging so much on this formalistic bit about, well, gee, if it was a government agent from NSA or CIA accused of wrongdoing, the privilege invocation would be somehow inherently more meritorious? I frankly don't see much merit in that. Now, what about the bit about the nuclear option that the privilege is being deposed not only to block discovery, but get the case dismissed, particularly dismissed in the pleadings phase? Now, I understand, I'm a practicing lawyer, I understand the significance of it. Since I usually do defense work, we all love to get the case dismissed in the pleadings. But again, let's be honest here. Discovery is an important tool that the plaintiffs use to burden the other side. There are all sorts of other devices that you can use to knock litigation in the pleadings phase. The teaching of Twombly and Iqbal that goes to the palpable insufficiency of the pleadings. You got other doctrines. And, look, from a standpoint, it's not something I would hang my hand on, but just from a standpoint of judicial economy, the plaintiffs do bear the burden of production and persuasion if you can make a reasonably compelling case that they would not be able to marshal sufficient modicum of evidence to discharge that burden because you would interpose in discovery, then what is the reason to go forward except to engage in a bit of symbolic theater? And a lot of litigation is that, to be sure, but I don't see it as being sacred. So my point here is there are many other procedures to derail lawsuits at the pleading stage, and I'm sure some of my colleagues would like to push back and deconstruct the robust invocation, for example, of Twombly and Iqbal, but we can save that for questions. But let me tell you where we most fundamentally disagree. We've heard a number of points made about how these policies have been used. The promiscuous invocation, the nuclear invocation version of the state secrets doctrine to shield the government from wrongdoing. I have a somewhat more nuanced view of the policies involved, but to me it almost doesn't matter because interesting things, ladies and gentlemen, about our constitutional architecture is the emphasis on procedures and processes. Even if you assume that what Vince and Amanda and Ben had to say about Bush administration policy is entirely true, it does not follow that the remedies they seek are appropriate. And the thing that troubles me greatly, and I actually wrote an article in Slate, of all places, fairly recently, is this notion that if you cannot get an Article-free judge to preside over something, but that is a horrible violation of separation of powers and leads to democracy deficit and lack of accountability. The framers would be very puzzled by that because the Article-free power, in principle, is much more narrow than the sphere of activities by both political branches. Remember, the Constitution doesn't constrain only Article 1 and Article 2. They constrain Article 3. There are all sorts of barriers. You can have horrible wrongdoing. You have a clear victim, hideous conduct by the defendant, and there's some barrier to justiciability. You got the political question doctrine, particularly the constitutional prong thereof, not the prudential. You can have problems with standing. You can have problems with remediability because you're not supposed to invoke judicial power unless you have a judicially recognizable remedy. The framers would be very surprised to grasp the notion that everything that the political branches do has to end in courts. And if you don't end, and I had a little funny exchange before the panel started, and I think, well, not to put words in my mouth, but we'll both agree. It's fundamentally, ladies and gentlemen, it's not about the rights of the victims. It's about judicial supremacy. It is about the notion that every discretionary activity of the two political branches, primarily the executive, but also Congress, to the extent Congress authorizes something, must end before an Article-free judge. And what does it mean, must end before an Article-free judge? That means the Article-free judge has to be the one ultimately, because if it ends before him, he would indeed have a final say. Okay, under Marbury v. Madison and various other interesting cases. Pray tell, how is it that an Article-free judge is supposed to engage in a free-ranging exercise of whether something would significantly harm national security? Now, there are some examples I'm aware of in various statutes. There is a provision, for example, that governs litigation where a recipient of the national security letter seeks to disclose or exercise his First Amendment rights and wants to make this information public. And there's a statutory box that Congress created that has similar language and has similar senior executive branch officials attesting to that. And very constitutionally challenging, particularly in a situation where Congress has not prescribed clear standards. And there are certainly times, where, apropos of a State Secrets Protection Act, because they would presumably do that there, is this entirely congressional right under Article 1 to completely trump the executive's determination of something causing significant... What if executive sincerely believes that it would cause significant harm, but an Article-free judge who has life tenure disagrees? Who shall win? And by the way, State Secrets privilege, these are labels. Let's pretend we didn't have U.S. v. Reynolds. Do you like political question doctrine? Does it have any, and I'm repeating it for the second time, does it have any constitutional heft? Why isn't it a proper subject? And I know that's not how it evolved as a matter of litigation tactics, but why isn't it a classical candidate for the nice language in Baker v. Carr, but even before that, lack of judicially ascertainable standards, clear delegation of responsibility to the other branches? All right, a couple of other things very briefly. I will perhaps surprise you by defending this administration's reforms. Why do I say that? Back to a point about, everything has to run through judicial vortex. There are many other ways of ensuring accountability. There's political accountability bolstered by the fact that of a competitive relationship between two political branches and they're both controlled by the same party. My days in government and thereafter, I've seen lots of intra-executive branch bureaucratic accountability where, frankly speaking, agencies are feuding. CIA versus FBI, DOD versus state. And they leak, and they point fingers at each other, and the media writes about everything. And you have tensions even within the same agency, within the CIA, between the analytical side and the operational side. And the IGs are flying everybody's ointment. We're not lacking in checks and balances. We have more checks and balances than any country in the world. And is it really fair to say that people got away with impunity? Whether it's enough or not, but let's stipulate people had their careers derailed. People are being pilloried. People cannot teach. Everything has been printed in New York Times and Washington Post. There's plenty of accountability. And what the Obama administration's executive order does This is a good thing. I mean, I'm a big proponent of executive power, but I love the notion that people need to know who authorized what. So it's good that you elevate it to the cabinet level. It's good that DOJ exercises the functions of scrutinizing assertions of privilege by other agencies. I wouldn't even mind if a decision was made the president has personally to sign off on it. Because if you're doing something wrong and it eventually leaks, people pay political price. And that's real, that's palpable, that is not immunity. One final point. What should Congress do, and what about the victims? Well, by the way, Congress doesn't need to write new statutes if Congress cares about getting information. Congress knows plenty of ways to get information out of executive from a normal oversight process. You can hold up nominations and confirmations. You can hold up promotions. You can fence, budgets and slash budgets. You don't need to be reporting, have executive report on the number of times used the privilege. But that's benign. I don't really care. But I tell you, a solution I would certainly support, and it's interesting because I think some of you may agree with me, let's pay people money. Let's have a compensation model. Do you remember the Airbus shoot down by USS Vincennes? The United States did not admit liability, but clearly was a mistake. It was a civilian airliner. And we paid some money to the Iranian victims. In a situation like Maha Arar, I would have no problem with Congress creating something akin to a judgment fund, where if to the extent people really want money and not want to engage in lawfare, not want to engage in a symbolic and practical reshaping of a future governmental policy. What they want is money for their suffering, money they should get, and you can have an arbitration process where awards are being made with absolutely, ladies and gentlemen, zero involvement by any Article III judges. Congress should create that. You take care of immunity and accountability for other ways, and you take care of victims' rights properly construed for this compensation mechanism. Everything else, again, is nothing more than an effort to fundamentally change our constitutional architecture in ways that are very unhelpful in the long run. Thank you.
Thank you, David.
Can I just clarify one thing that I think David may have mistaken my litigation strategy for my opinion, but otherwise, yeah, go ahead.
So I want to pick up on David's sort of political question point, which I take it is that there's always a problem with any branch of government having final say on an issue, because that branch then is in some sense not checked. But we also have to make decisions about which branch is institutionally best suited to have final say with respect to a particular question. And I take David to be saying that when it comes to assessing whether a particular disclosure will in fact cause significant harm to the national security, as between the three branches, the executive branch is best situated to do that Congress is not particularly well suited to do it because it leaks like a sieve, and courts, while they are probably less likely to leak than the executive branch, they, by definition, have a more narrow field of vision, and so may not be in a very good position to second-guess a decision by the Attorney General and the head of the intelligence community that a particular disclosure will jeopardize national security in a significant way. And so the real question is would it be constitutional to give courts that kind of final say with respect to something over which they may not have the appropriate expertise?
One thing, very briefly, and again, David, not to be super nice, but you put it very, very personally. It is a question of who has the final say. The only point I wanted to add is we should not approach this salami slicing like it's not just about who determines whether harm to national security takes place. Because if you take the position that the political question doctrine, which is a label I prefer here, does not constitutionally prohibit the courts from getting into such areas. There are zillions of other discretionary judgments by two political branches. There would always be, David, subject to judicial review. And then instead of having constructive sort of Newtonian tension among the three political branches, where you have checks and balances, but each branch has some irreducible modicum core of autonomy, and I'm repeating what I wrote in Slate, we basically would have judges running everything, because they would have a final say in everything. And that would surprise, and I'm sorry, it may sound simplistic, but you cannot be both ways. So if you go down in the direction, why wouldn't you go down the direction of defining what is a battlefield and what is sufficient control? And these are not hypothetical issues. We're talking about cases like McCulloch, which is now in the D.C. Circuit. So there's so much at stake here. It's not just about state secrets.
All right, well, okay,
Yeah,
Ben.
I don't think I know what salami slicing is in this context, but it seems to me that here in the press club, the standard that David is articulating would dictate a different outcome in the Pentagon Papers case. Because in that case, the government in their briefs, the Solicitor General said, at the highest levels of the executive branch, we have reviewed this material, and we have made a determination that the release and publication of this information would cause exceptionally grave harm to the national security. Once the executive branch has made that determination, it is not for the courts to second guess. Now, Erwin Griswold, who wrote that brief, 20 years later published an op-ed in the Washington Post in which he said, in all this time I've never seen a trace of a threat or harm from the publication of the Pentagon Papers. So I do think that this question of who is better situated to make these judgments, it's so often discussed in terms of deference to executive expertise. But in these contexts, I think there really is a structural conflict of interest. When you have the same entity that has the most to lose from the publication of it, in terms of not just embarrassment, but sometimes liability, if we're talking about torture, asking for extreme deference to its determination that publication would cause harm. Well, harm to who? And is the director of the CIA in a better position than a judge, to determine whether this evidence at the beginning of a lawsuit is relevant or needed? I mean, remember that the CIA director, the former CIA director, Mr. Hayden, when it was revealed that CIA interrogation tapes had been destroyed, his response in a press release was not to worry. We had already determined, the CIA had already determined that these tapes were not relevant to any ongoing judicial or legislative proceeding. So no worries. Well, this is the same person who is submitting affidavits to a court saying, I've determined that evidence that is a state secret is so critical to plaintiff's case that it has to be thrown out before it even starts. I actually think that an Article III judge, who, in fairness, isn't an expert in anything, we hire him because he's a generalist, right? He's not an expert in any other issue either. But he has been appointed by a president or she and confirmed by Congress. As David just suggested, there are fewer weeks of national security information out of the judicial branch than out of either of the other branches, and I don't think that that's really arguable. But I think that person, who will defer to the government in 99% of the cases under any standard, is in a better position to make sure that that 1% doesn't also get thrown out.
David, if I may, very briefly, with respect, the interesting question or the relevant question is not who is both better suited. We're not sitting in a political science class trying to create a new constitution. Okay, even if I agreed with you, and I don't, that Article III judges are best judges, no pun intended, of that process, we have a constitutional architecture. The constitutional architecture stipulates that we have free, coordinate, and independent branches. I don't know of any serious constitutional scholar who would accept willingly the implications of letting Article III judges scrutinize every discretionary decision, because there's nothing fundamentally different between a decision whether something would cause significant harm to national security and a decision that you need to go to war because you believe that there is a threat posed or a decision to engage in some other conduct. If you go down this path, you're on a slippery slope of putting judges in charge of everything. And that cannot be. It may be a good idea.
Because don't judges do that under Exemption 1 of the FOIA?
FOIA is, there are interesting questions about FOIA and interesting questions about the statutory regime I was talking about. I don't believe that the executive has the plenary power across the board on national security. That power is substantially shared with Congress. Then Congress comes up with very clearly ascertainable standards about this. You can, but I'm almost do a Schechter poultry type argument. Congress cannot transfer to an Article III court the right to have a discretionary super review of executive. So, for example, if you want Congress to come up, not to give you ideas how to write it, with 15-factor test about what is a significant harm to national security. That renders judicial discretion, makes it much more cabin. I would be not entirely happy, but much happier with a statute. But something that tells an article-free judge, you, using your discretion, determine in the end what is the significant harm to national security. That situation is patently unconstitutional, given, again, the constitutional structure we have.
Just to jump in maybe a little bit of a tangent, but building from what Ben said about courts being deferential to the executive in most cases, I mean, we are sort of, those of us up here on the panel who would like to see the State Secrets Protection Act become law, are fighting for judges to be more involved and to take a larger role. And yet we have to admit, all of us who are familiar with the way the Freedom of Information Act works, which has an exemption for national security information, and other cases that come up before the courts that involve questions of national security, courts are extremely deferential to the executive claims of privilege, too deferential in my view. I mean, there was a Supreme Court case where the court deferred. Congress rewrote the law to make it clear the court should be less deferential, and it really didn't change the way the court approached these cases. So I may agree, although I think not for the same reasons, that maybe the courts aren't always the best or the only branch that should be checking the executive. I would like to see Congress be more involved in oversight of claims of privilege. And the State Secrets Protection Act, the bills pending, do have some provisions addressing that. I'm sure there would be problems with that mechanism as well. But what I can't agree on is the idea that the executive gets to be the sole decision maker on this. And I think our constitutional structure is, we just disagree. I think that that's the very goal of our constitutional structure, is to prevent the executive from doing things like detaining and torturing either its own citizens or other countries' citizens, and being the final arbiter of whether that's constitutional and legal.
Okay. If I could raise a slightly different question. One of the biggest complaints that I hear both Vince and Ben making is the use of the privilege as a kind of a defense to charges of illegality. And I guess the question is, what is the appropriate response? What should be the appropriate response from the courts or from Congress in a situation where there is a credible claim that revealing facts would undermine national security? And the government's claim is not that the plaintiff can't go forward with his claim or her claim, but rather that the government itself has its hands tied behind its back in terms of being able to defend its program. So take the Khalid al-Masri rendition case. The government's argument was essentially, or one version of the government's argument would be, if he was rendered pursuant to a covert CIA operation, which we think is perfectly lawful. We're not conceding that it's unlawful. We think it's lawful. I think it's satisfied. We've reviewed it. John Yoo gave it its stamp of approval, so it must be lawful. But we can't, without undermining the national security, we can't make that claim. We can't advance that claim in court. And therefore, the only thing to do is to throw out the lawsuit. And as I read at least one of the two bills in Congress, it wouldn't change that result in a case like that. And I'm wondering whether, what is the appropriate result in a situation like that?
I think the law as it stands says that cases are not dismissed if they would if secret information would interfere with any hypothetical defense that a defendant might raise, although that's certainly the Fourth Circuit standard. But every other circuit that's looked at it has said that it would have to interfere with a valid defense. And if the government had a valid secret defense in Khalid al-Masri's case, the secret might be, we didn't do it, British intelligence did it, and that might be a legitimate state secret. In that case, the government should submit its valid secret defense to a court for in-camera review, and the court should dismiss the case on the merits and not on the state secrets claim. And that's what then Judge Scalia did in a famous case in the D.C. Circuit called Malario. He looked at the government's state secret affidavit and the evidence they submitted and said, it would be a farce to let this case go forward because I've looked at the government's defense, and it's unequivocally correct. But at least in that case, there was a merits determination. Now, I'm not so comfortable with a secret merits determination, but that's preferable to saying that because there might be some defense out there in the world that may or may not apply to this case and cases like it can't ever go forward.
And so this would be a secret merits determination in which the ACLU lawyer would have a national security clearance and would present its arguments in secret?
I would say that, I mean, you'll be surprised to hear me say this, but that even an ex parte in-camera merits determination would be far better than the situation that we have right now. And I would also say that one issue that David and I can absolutely break bread on is this notion of a compensation model that need not involve Article III judges. I really think that if there are cases, if this were really fundamentally about secrecy, we would see movement in that direction. And I guarantee you that if you and I write an op-ed together in which we propose this kind of model, there will be great gnashing of teeth by the CIA and the NSA who don't want to have any recognition that any wrongdoing was done. But
I'll be happy to join you.
I think Lee Casey will be very jealous.
Yes. There are times Lee and I are not on the same page. But let me perhaps add to my idiosyncrasy by pointing out that if nothing else, I'm very uncomfortable with the notion of secret adjudication on merits. I'm not a huge fan of FISA, court that functions ex parte precisely for that reason. Why is that? Well, maybe because I don't hold the courts to some exalted standard that differs from that of other branches. The courts have to be bound by the proper constitutional norms. Judicial power ought to be exercised not in the privy council setting, but in a setting of case and controversy. And pray tell, how is it that you have a case of controversy if you have an ex parte adjudicatory process between a government attorney and the judge? Well, how is it a case in controversy? If it's not a case in controversy, what the hell is an Article III court doing hosting a venue for it? I mean, it's like some of you is pedantic, but I have, and, again, we don't have time to get FISA is a strange animal because you have Article III judges populating it, but it clearly doesn't work as an Article III court. Again, unless, and this is an interesting thing, what Ben is trying to do, frankly, is to come up with some other way of getting an Article III judge to weigh in on it. If you assume that it is an absolutely paramount value, and then it's constitutional, you go for it. But why? Why wouldn't you have a different motto, if you will, of test driving? And look, one other thing. Call me naive, but so much disclosure and policy change is taking place. If you were from Mars sitting in this room and you heard about torture this and torture that, you would think we're still doing everything we've supposedly done in the Bush administration. Democracy works. Policies have evolved. Some people got kicked out of power. Other people came in. There have been meaningful changes in a whole range of policies. Heck, there have been meaningful changes, differences between Bush 1 and Bush 2.
Let me jump in if I can. A couple of things. One, David, it's hard to have it both ways, because what I heard you saying earlier was that you were much more comfortable with the government, with the executive branch being able to keep it secret, at least in the context of the way you thought of the constitutional construction, and that there was a certain that you feel that the executive branch can go deeper with its secrets and shield those secrets and not have another branch of government determine how to do it. But when we talk about the judicial branch, somehow the transparency light that shined on the judicial branch, I think, is something that you feel is a little bit more sacrosanct. So then it troubles you when we have the idea of courts that are operating largely in ultimately less secrecy than you're comfortable having the executive operate in. And I think, what I'm taking from this, and any time that we, hear Ben Weisner, of all people, at least thinking about what the best option is, and if that option involves some level of secrecy in the judicial branch, I think what it tells us, something that I think we already know, is that, at some level there is something different about national security post 9/11, and it requires us to think a little bit differently about how we safeguard the interests of our citizens and people that come into contact with the government, how we keep the government honest in terms of doing the right thing, and how do we make those determinations. So at some level, we seem to be talking about taking all branches of government a little bit deeper in the secrecy. The thing that I'm not comfortable with is saying that the executive branch gets to kick everything out of court, gets to hide things from Congress, gets to hide things from us, gets to put out Glomar defenses, and they won't confirm or deny anything, and we simply just have to live with it. And I think that where we're going is thinking that while it's a dangerous road, and it's not one that makes any of us comfortable, but I think in the age of security that we need to at least be able to think about ways in which the different branches of governments can provide the checks, if not the balances, by having access at least to the same level of information, so that when the decision emerges, David Chris talked about this earlier, that there is at least some public confidence that the information was looked at by more than one set of eyes, and that we can feel confident in the result that this falls into a serious situation and not necessarily into a Reynolds situation. And finally, the last thing, I don't think, David, that the framers would be as shocked as you say to see that that there's an expectation that the courts will look into all aspects of executive decision making. I think what is probably would be more shocking to the framers is if they saw the breadth of the executive decisions that are being blocked from judicial review, especially when those judicial decisions and policies involve credible allegations of domestic misconduct, illegality, and violations of international law, and that the answer is, I'm sorry, but our Constitution does not allow the judicial branch to make a legal determination as to whether torture, is essentially that we're talking about is declaratory relief. And the declaratory relief is not lawfare and it's not theater. It's declaratory relief, and that there is a right and an obligation, and it is better for courts to be able to say torture is illegal. The facts that are presented in the context of this case constitute torture, and it's unconstitutional. And that is the point at which future policies from this administration and future administrations can begin to divine how they need to think about the war on terror. Right now, there is simply no check on that. And I frankly think that while I am very much in favor of compensation schemes, I'm not in favor of compensation schemes that skirt the declaratory relief issue, because we will have a system in which there will be a national pot of money for the victims of 9/11 illegal activities under the Bush administration's fund, and that is not a substitute for really what we're talking about, which is ultimately the check on executive power.
Can I just very briefly?
And then we'll go to questions.
My apology. Vince, you got it absolutely correctly. I do not want courts to function in this fashion for a very simple reason. Again, we're not engaged in a freestyle policy exercise. Judicial power does not partake of this kind of stuff. The power exercised by both political branches does. Very briefly on the issue of, what the framers would be surprised. If you look at the extent to which the courts would discuss at the convention, the Federalist Papers and various other things, you would see that the framers believed judicial power would be very deep, but far narrower than the power of political branches, because the courts are singularly unsuited and not expected and not allowed to engage in discretionary judgments outside of some very narrow areas. If you let the courts engage in discretion in scrutinizing executive judgment, which is to say superimpose their judgments on the judgments of two political branches, with the notion that the judicial determinations are to be obeyed, when our entire government is run by the courts. And there's no third way, I'm sorry. There's no way you can let them in the tent a little bit to scrutinize outrageous determinations by bad presidents and bad Justice Department officials.
You know what I think is great is that the court, if you look at the three branches today, the Democrats control the presidency, Democrats control the Congress, and the courts are controlled by the Republicans. And yet here you have David saying, keep the courts out of this.
But David,
so there's a
about
man
the
of
Constitution and not expediency.
All right, let's take questions from the audience. Sir. And if you could introduce yourself, Dan.
Dan Marcus. I teach at AU Washington College of Law. I teach separation of powers. I believe in separation of powers. I even believe in executive power. But what about the reverse separation of powers question here. Even if courts have a limited role, the heart of that role is adjudicating cases or controversies. That's what Article 3 is all about. And isn't there a separation of powers issue going the other way that suggests this isn't so simple, which is the executive, by filing an affidavit, preventing a court from adjudicating a case or controversy? And shouldn't we take that pretty seriously?
I understand the point. It is a creative tension. I hate to use the word dialectics. It's kind of a European way of looking at it. But look, notice
old Europe too.
Notice what I'm not saying. That there are many instances where the courts are able to block. See, I happen to think that Congress can poach to a great degree on the executive branch's authority here, provided Congress proceeds in right ways. With regard to the courts, if Congress wants to let the courts in, they can let the courts in. And I understand the problem with a mere declaration is that it can block litigation on a variety of fronts. But it doesn't follow that because this bad possibility exists, that you cure it, because I would ask you to flip it around. Typically, your students don't do that. What is the limiting principle? If you put judges in charge, as David and I think Amanda, well, you didn't describe in detail how the statute would work, but you would agree. In effect, it would allow the courts to have a final say. And based upon what standards? A totally open-ended discretionary standards, okay? Not to sound like, Leah Strauss or Harvey Mansfield, but discretion is the essence of executive power. The essence of judicial power is ruling in accordance with prescribed rules and criteria. Now, there are some exceptions about what's reasonable, et cetera, but if you, in an effort to remove this blockage that bothers you, empower the judiciary to override it as they see fit, then the separation of powers is destroyed because they govern everything. And I don't know what the third way. Third way, very briefly again, is Congress coming up with very clear criteria in a totally exhaustive Clean Air Act or tax statute-like format where you look at the 14 factors and the court is told how to rank them.
But David, you talk about discretion and the executive's exercise of discretion or the court's exercise of discretion, but the executive didn't have discretion to warrantlessly wiretap or to send people to countries that torture knowing they would engage in torture, right? That was clearly a violation of the law. And your response to our concern about that was democracy works, Obama got elected. But those laws were violated. I don't also think Obama was elected solely or even mostly because of the difference in policy. But even if I were to grant you that, those laws were violated. And for those individuals who were tortured or who were wiretapped, democracy did not work because democracy is the rule of law, and the people that violated those laws have never been brought to justice.
With respect, Amanda, we're talking past each other because you're conflating the question of whether or not the executive engaged in substantive underlying misconduct, and let's stipulate if executive acted extra-constitutionally or in violation of a valid statute, it was a bad thing. But that is a totally different question from whether or not the executive can prevent the adjudication of that matter in an Article III court by interposing in a nuclear option mode the state secrets privilege. Because, look, where else to stipulate? Is your view then that because this particular pattern, based upon a particular interpretation of allocation of constitutional responsibility, produced bad results? We got to eradicate bad results at all costs, and we're going to come up with this scenario, and my answer to that is it would fundamentally distort constitutional allocation of powers. And your point back to me is, but this other allocation produced all those wrongs. That's not how the Constitution works. It's not enough, even if you assume that everything that was, let's assume, arguendo it, everything the executive branch done during the Bush administration was wrong. And every single invocation of privilege was in bad faith. In my view, it still would not be enough. There are other ways in which the Constitution deals with these problems for political accountability, political checks and balances, and, quite frankly, criminal prosecutions. If a successor administration, I'm not a fan of it, but at least there's a theoretical possibility, is being kicked around.
I'll write that up, Ed, with you, by the way.
I didn't say it was a good idea, but it is certainly constitutionally permissible.
All right. Next question. Yeah.
Hi, I'm Sharon Bradford Franklin with the Constitution Project. I just want to follow up on David Rafkin's most recent answer to see if I understood what you were saying there. You were previously talking about your constitutional concerns with the courts playing this role, but then you said Congress could have the power to bring the courts in as long as it had clear standards. So I'm curious what your view is of the constitutionality, not the wisdom, but the constitutionality of the State Secrets Protection Act bills pending.
I don't think it passes this threshold or meets this requirement because you do not have a very clear statutory framework. And in some sense, not to be disingenuous, I understand why. Because it's very difficult to cabin a discretionary or review, scrutinize, whatever verb you want to use, a discretionary determination. But clearly, one thing that Congress cannot do is to say, hey, Judge, you go and decide on your own whether it's, and it doesn't matter what the standard is, whether it's very significantly threatens, awesomely threatens, significantly, or threatens because it's all discretionary. Well, I don't know. I need some time to think about it, but I could try to write a 5 or 6 factor that in some situation would make it a more structured exercise of judicial power. But, boy, am I crazy to think that there's nothing un-American about the notion that judges should not exercise, and I understand the equitable power of the courts, that judges should not engage in open-ended discretion decisions, that that's something that political branches do and the courts are kind of different.
But FOIA and FISA and SEPA all empower judges under defined standards to overrule executive determinations about whether information can be used and whether harm would flow from it. I mean, those statutes do exactly what you say that this statute would do. And that's why I asked you before, do you think those statutes are unconstitutional?
No, I've litigated in both sides in my out-of-government days in the FOIA. No, I don't think that FOIA is unconstitutional. It does provide more factors. But again, we're in a very delicate area. It's like, trying to figure out how much the Congress exerting to the utmost Article 1. I mean, separation of powers is not mechanical. Each branch can push very hard against each other, but at some point in time it becomes too much. We completely emasculate the other branches.
So I'm now litigating in this district a case trying to get additional documents released from Guantanamo Bay that the CIA would like to keep classified. The final decision maker in that case is going to be Judge Lamberth. Right? I mean, the director of the CIA has submitted his declaration. I've submitted my brief. And the CIA director has said, I think there will be exceptionally grave damage to national security if these documents are released. I've said I think that's bogus. A judge is going to make that determination. That's why it seems to me exactly like what we're talking about under the state secrets privilege.
There is more cabining of judicial discretion in the FOIA context than in the State Secrets Protection Act. And there's a great deal of case law, and FOIA, and I would have to say the courts have acted essentially responsibly by and large. Well, I don't know of any instances in the FOIA have not acted responsibly. So it probably is more on the right side of a line, but it doesn't mean that, we should charge ahead and do more.
But it means that there could very well be constitutional legislation that achieves what we would like to achieve. It just would have to look more like the way Exemption 1 works under FOIA.
Well, I said that in my remarks.
Yeah.
That should be part of the op-ed, too.
It will be.
Let's see. Oh, yeah.
Hi, I'm Martin Hindle. I'm a criminal defense attorney in the military commissions for an Afghan who's been detained at Guantanamo for 7.5 years, and he's been pending sworn charges for 14 months without referral, which means nobody's designated for him for trial, but he's in this limbo. That's sort of hard to explain because there's no civilian counterpart to that. But because of my wardrobe choice this morning, I want to preface my comments by saying whatever I'm saying here is my own personal opinion. It's not the opinion of my office, the Air Force, the Department of Defense, or the military commissions. I've been very interested by this conversation, and I do agree with the sentiments that were shared along the lines that the state secrets doctrine, in my humble opinion, is run amok. And it is very dangerous, in fact, to let the executive have sole the sole decision about whether a particular item of information should be protected under the state secrets privilege. And I wanted to add to the conversation because I have the perception that we've been talking largely about civil litigation and lawsuits against the government, either in habeas or by private citizens. And I just want to say from the trenches, as somebody who's done criminal defense in the commissions, I have personally witnessed what I consider very adverse impacts, the trickle-down impacts of this doctrine. And I'll give a few quick examples, and then I'd like to sit down and take your responses. I have a top secret security clearance, and like anybody in my position, I'm sworn to preserve information that I get that's classified. Notwithstanding that, if I come into any classified information, I can't use that in talking to my client because he doesn't have a clearance. I can't talk to him in the privacy of our attorney-client relationship and ask him about that evidence. And it just so happens that after 14 months of representing my client, I've received not one shred of evidence from the prosecutors, from the government, in the form of discovery in my case. Why? Largely because they are told not to give out any information at all until it's definite that the case is in fact going to trial. And colleagues of mine whose cases have gone to trial have received thousands of pages of evidence days before trial. That's where we are with this. Also, as you may know, the so-called high-value detainees, whatever they say to their attorneys is presumptively classified. So if Khalid Sheikh Mohammed tells his lawyer that he had cereal for breakfast, that's presumptively top secret. Furthermore, when I go to my habeas facility and I'm involved in the habeas case, if I learn information there that's classified, I cannot come back to my office and share it with my co-counsel in the criminal case who also have secret security clearances. Even though we're all properly cleared, we can't talk about that because the Chinese wall has been erected. In all of these cases, I would submit it's the runaway fear of the leak of some vague, dangerous material. The leak to people who are already cleared, whose duty it is to use this information in the criminal defense of their clients. And I'm rambling a bit, but I just wanted to ask Mr. Rivkin, because you said, I believe, in your opening comments, that one of your concerns in allowing Article III courts and judiciary to review these matters is that you would have lawfare or you'd have spurious litigation by bloodthirsty plaintiffs' lawyers. And I just want to emphasize this is hamstringing criminal defense attorneys in a very visible criminal prosecution, and I'd be interested in your comments. Thank you.
I think what we should do is give everybody a chance to have for a brief response, if you so choose, or brief closing remarks, and then we'll close the discussion. So, David, do you want to take the first shot?
Very briefly, I mean, you said a number of things, some of which are obviously troubling, others less so. The fact that you cannot share classified information with your client underscores, I think, some unavoidable challenges and tensions between your obligations as the member of the executive branch or somebody who's been indoctrinated and availed of a secret clearance and the obligations as defense counsel. Which way does it cut? If your position would be that your ethical obligation as a counsel is always to disclose the information to your client because, he may be, and I understand the argument, he may tell you, for example, something that you don't know about that would enable you to challenge this information and weave it together into something else, classical. He is told, you hear that so-and-so said he was, hugging bin Laden, and he will tell you, oh, this guy's my enemy because, we fell out of a girl in high school. I understand that, but if you take the position that your ethical duty to a client override it, frankly, then I would, speaking if I were in the government, say you cannot get ever any security clearance because there's a prima facie evidence that you not abide by the restrictions. So that, to me, is a tough issue, but I don't have an easy solution. I don't quite understand the Chinese wall situation. It's somewhat bizarre. Of course, there's typically a clearance and a need to know, but I guess, I don't know. It seems like a lot of things the government does are stupid. I'm not offering any ringing defenses, but I would just underscore one point. Look, the government is losing. Shoes another foot. The government is losing vast majority of a habeas cases, probably 90%. And the government is going to release a lot of people at least some of whom, many of whom, should not be released, who are going to go back to fighting and do many bad things. So, and yes, some people probably were held for many more years when they should have been held or shouldn't have been held at all. I mean, I don't know of any system that does not allow for mistakes. It's a question of balancing, and you all can make your own judgments about how we as a democracy balance those things well. But I don't have any simple answers to that. But what's the answer then? The answer is let's change our constitutional system and let the judges sit in decision and everything and dramatically curtail government secrecy?
No, well, let me jump in. I think, first of all, I want to thank you for the work that you do, because it's critically important. And organizations like CCRs and the ACLU, and we go out there and do a lot of the work. You guys do tremendous work. You don't talk about it. You're not getting the glory for it, but we recognize that it's really hard. On the security clearance issue, I'll point out that, and David, this is sort of how this works, which is really interesting. When we at the Center for Constitutional Rights were engaging in representing of the men in Guantanamo, a total of 778 men, there came to a point in 2006 where 14 so-called high-value detainees were brought to Guantanamo. We then sought to begin proceedings to represent those men in habeas corpus cases, and the government said, no, you can't do that. And we said, why? And they said, because they are in possession of top secret classified information. So you can't represent them because you don't have the proper security clearance. And we said, well, what are you talking about? And they said, well, they have knowledges of the sources and means of the interrogation policies, and therefore only people that are classified that can get that to receive that information from them are entitled to represent them. And so we were saying, so you're essentially saying that because these men are saying that they were tortured, and you're not at this time, they weren't admitting that they were torturing, and they were waffling about whether waterboarding was torturing, but they said because these men were being tortured, you're saying that they are now sort of these classified pods, and that no one can talk to them because they have classified information. And so they said yes. So we went down and we got CSI. A couple of our lawyers have CSI security clearance, which ironically enough for the Center for Constitutional Rights is higher security clearance than a lot of the guards in Guantanamo. But the Chinese wall, and I don't like using that phrase, I can't think of something else off the fly in the time that I have left, but the wall of Asian descent that is that we're talking about here becomes very critical, because you have a situation now where if Ben were to file a FOIA request or to seek documents relating to information about CCR's clients, CCR wouldn't be able to tell Ben because it's classified information. What the client told CCR or told the lawyer there would be classified, and Ben wouldn't be able to get that. And that, in fact, the client itself doesn't have access to the information that would exonerate him or confirm what he was saying, because that is confidential and classified as against the client. So quite literally the only entity that has all of the information is the government. And of course we know that the government is running the military commissions as well. So when we talk about separation of powers and we talk about what the solutions are, one of the solutions in that context is, in the criminal context, is just to throw out this military commission's ridiculousness, that these men should be tried as a matter of policy in Article III courts. And then we can get back to the question about that's been raised in the state secrets context, which is, well, how are the judges going to handle this confidential and classified information? But I think what happened here was that there was another very interesting and troubling layer that was put on. It's hard enough in the context of civil litigation, but it becomes deeply and much more troubling in the context of criminal. One other thing that I'll just sort of point out here, which is a point that Ben has made a lot and David has made a lot as well, to the extent that the government is saying in the rendition cases that this information is classified, the cruel irony of it is that Khaled El-Masri and Meher Arar know exactly what have happened to them, and you know exactly what happened to them because they have talked to you about it. And so quite literally, the only place that they can't talk about it because of the state secrets privilege is in the courthouse.
I don't need to.
Just in less than 30 seconds, my response to you is that what you're describing in the criminal area is the same problem in the civil area, in the sense that in both situations, my concern is that the government is not being put to the proof. It's not being required to get an independent decision maker to sign off on its legal determinations, and that's, I think, what the debate is about here. So I see the parallels.
Thanks.
David, just 10 seconds. Also, I'm remiss for not thanking you for your work. And let me just point out, hopefully nobody can argue anymore that having government lawyers represent detainees somehow leads to a lessened and inadequate defense, which frankly a lot of critics made the argument, because I think they've been incredibly robust, both in defending specific defendants as well as pushing against the system. So military justice is to justice not the same way as military music is to music.
Thanks. And I want to say I earlier praised David for being principled for arguing against the Republican courts in favor of the Democratic Congress and the presidency. But I think we also have to recognize that Amanda, Ben, and Vince are being principled in seeking to empower the Republican-controlled courts against the Obama administration. So I think this principled panel deserves a round of applause. Thank you.